Rogues, rascals, reviewables, rorts, rip-offs, receivers, real estate agents, and much, much more. The Many R's podcast. Season 1, episode 7.5. 7.5. We can't get all the way to 8. We have to go to 7.5. And we have absolutely breaking news from the New South Wales Supreme Court about one of our favourite R's, Ralph. So stand by. Welcome to Season 1, episode 7.5. If you've got any questions, give us a call on 1300 327 123. That's until late. Or hook up with us on dcpartners.solutions/podcast. Use the chat tools in the bottom right-hand corner. Thank you. Well, welcome. This is an unusual set of circumstances. This is episode 7.5. This is a follow-on episode from our last one where we talked extensively at the end there about our very good mate, Ralph Palagaru. And we happened to run into Ralph recently. Here's some updated photos on Ralph for you. But this particular episode is about... Well, a judgment of the New South Wales Supreme Court has literally just come down and it is still hot. It is still warm. So we're going to have a look at Ralph Palagaru, John Mahoney, that's the lawyer, or is it Mahoney? No one has ever explained that to me. We've got Mohan Kumar, who is sometimes known as Chottarajan, and we're going to have a look at, he's a resident of Tihar Prison in Delhi in India, and we're going to have a look at the Supreme Court judgment in the matter of Mohan Kumar and the Registrar General of the Torrens Assurance Fund. So this is a public document. And in fact, this has just come out, unbeknownst to us. We don't watch these things day and night, but someone brought it to our attention that the judgment had just come down on, it had come down before we'd actually put out episode 7. So we felt it was only right that we updated the record. So let's get on and we'll have a look at the judgment. Okay, so this is the judgment of the New South Wales Supreme Court, and anyone that wants to Google this can go to a site called caselaw.nsw.gov.au, and just Google that. And it's a set of proceedings, the 2021 proceedings. It was heard by Justice Dark, who I have to say, I'll make some comments as I go through. I think he's got it absolutely substantially correct. He wouldn't know some of the very tiny minor facts, but still it's well worth having a look. But look, the whole gist of it is the claim for compensation, a claim from Mohan Kumar for compensation from the Torrens Assurance Fund is refused. So that's the decision. So we can go through and have a quick look. Well, we can have a long look, but anyway, it's a very extensive document. I'm just going to highlight some of the relevant bits. There's quite a lot, and I'll publish the entire document up on our website, www.dcpartners.solutions. I'll include some text so you know what to look for. But anyway, the Registrar General of the Torrens Assurance Fund, or the Land and Property in New South Wales, titles are kept for land, and those titles are kept in a central register called the Torrens Title Register. So, and when a person loses an interest in land, if it's either by fraud or by some error made by the Land and Property, by the people that keep the titles, then that person that suffers loss is entitled to compensation. And every time there's a dealing, every time that there's a transaction involving land, a caveat, the registration of a mortgage, the transfer, when you pay stamp duty and all of that, a very small sum is collected and it goes into this fund called the Torrens Assurance Fund, just in case anything goes wrong. So I can say that the Torrens Assurance Fund, or the Registrar General, was represented by someone called Patricia Lane, who happened to be one of my lecturers at Sydney Uni. And you can see here whoa, it says here, okay, well, pardon me. The plaintiff was represented by Patricia Lane. Wow, how very, very interesting. And Mr. Mahoney was there as well. So I'm sorry, I got that around the wrong way. Very, very, very interesting. Patricia Lane, nothing but absolute respect. She was a fabulous teacher and unbelievably knowledgeable. I might have got that the wrong way around. I assume that this is correct. So these proceedings are brought by Mohan Kumar. There was obviously no discussions about who Mohan Kumar is in fine detail, but he certainly was the registered proprietor of land at Old Northern Road at Dural, number 632 Old Northern Road, Dural, and that was, if you like the word sold, it was sold in May of 2016 by his power of attorney, Ralph Palagaru, to a company called Bargo Developments Proprietary Limited. And I'm just going to sort of, these are public, and we'll just talk about these. So Mohan Kumar has claimed an interest in the land as what's called an unpaid vendor's lien, and I absolutely I met Ralph on or about the 27th of March in 2017, and he was introduced to me by Mr. Steinberg from Reliance Leasing, and Ralph complained he couldn't sleep at night because he was worried sick about whether he was going to get paid. So when I say this property was sold, he wasn't paid. So it was a property piece of land worth $5.5 million, which they received only $1.5 million. So Craig Adams is walking around with the title to a $5.5 million piece of land, having been out of pocket virtually nothing. And we'll have a look. And the money he received, he didn't pay it all to. He mortgaged the property and did not pay it all to Mohan Kumar. So as I said in episode 7, that is apparently the fault of the Torrens Assurance Fund. And Justice Dark did not agree with Marnie lawyers, and the claim was refused. So we'll just touch on some of the highlighted points, and if you're really that interested, you can download this and read this in fine detail. But Justice Dark finds that at certain times the interest was protected by caveat. So the very first thing that I did, I was asked by Mr. Pelagaru, how do I put it? I can't sleep. And I said, well, why don't you just put a caveat on it? So we went and put a caveat on, and that was put on about the 27th of March 2017, and that's how I know when I met Ralph Pelagaru. So it was protected by this caveat at some times. However, during other periods, there was no caveat, and at that time, Mr. Kumar was under the care of John Marnie and Ralph Pelagaru. So, precisely why they took them off, we don't know, other than what's in this judgment. So we're just reporting the facts. There's no criticisms whatsoever of Justice Dark or the decision he made, and none of this is a massive surprise. But anyway, look, there was various different mortgagees at various different times. Craig Adams. The argument is that, the argument was, which didn't work, was that Craig Adams made use of a withdrawal of caveat form that had been executed on behalf of Mr. Kumar by his attorney, Mr. Pelagaru, Ralph Pelagaru. And look, ultimately, Craig didn't pay his mortgage. The property was sold by Cassinda. This is a fact. And then there was a huge argument about who got what. And I was there, so I know it. The proceedings were resolved by way of consent orders made in July 2019. Now, I did actually put up the consent orders in episode 7, showing exactly who got what. And I've put here, now this is not a criticism of Justice Dark, but I'm just saying the plaintiff received a total of $527,000 out of $2 million. So he was owed $4 and he received $500. And this is saying, well, he actually received 26% of the available funds. But that's not, with no disrespect to Justice Dark, that is probably not exactly correct. And Kumar actually received 2 lots. He received 26%, but on top of that, he received another 9%. And who did he give that to? He gave that to one of my companies. And why did he do that? So, in fact, when you look at these arguments that Justice Dark talks about and says, well, hang on, I've done my calculations to work out whether you lost money or you didn't. And then he talks about causation. Who's to blame, in other words? Who's to blame for Mohan Kumar not getting $4 million, or $2 million of the $2 million? And look, Mohan Kumar actually did receive 35% of the available funds, so there was $2 million and something available. But he chose to honour an agreement he had with me where he actually assigned Ralph Pelagaru actually assigned all of Mohan Kumar's interest, the whole lot, to me, and I had an arrangement where I was going to pay a success fee, and it turns out that actually the success fee is 26% of what was available, and my cut was 9%. So when you look at these arguments as we go further down into the document, this is no disrespect to Justice Dark, but he did in fact receive more than 26%. He just gave away 9%. So it was 35% of the available. So again, absolutely no disrespect. So the plaintiff, and so in these circumstances where he actually got 35%, the plaintiff alleges that he has suffered loss or damage resulting from the operation of the Act, and Justice Dark didn't go for that. So and then it gets into some very long analysis. The loss, they're saying suffered loss by consequence of the registration of the Cassinda mortgage. So it is true that, and I've numbered all of these. So let's maybe have a look at these salient facts. And these are facts found by a Supreme Court judge, and nothing but respect. So absolute fact. The the plaintiff, Mr. Kumar, resides in India. Well, it doesn't talk about where, but or even who he is. And actually later on, there's a very curious remark saying, well, for some reason the plaintiff didn't appear, he didn't come and give evidence, and there you go. Well, the reason he couldn't give evidence is because he's in jail. So it doesn't seem that that fact was shared publicly. But look, here are the passport photos and photos of the arrested person, and you tell me if they're the same person. I'm not an expert, and I've never been to India. I've never been to any jails. I've never met Mr. Kumar. It's just it's an open secret that that's who he is, and no one bothered to share that with Justice Dark. So look, the piece of land was, as I said, 632 Old Northern Road, Dural, and there's its title particulars. Ralph sold it. I've showed you the front page of the contract in episode 7 for 5.5, but in fact they received 1.5 was put down, and there was a series of arrangements that Craig Adams was to pay 500 there and $1 million here and another 2.5, and time was of the essence. And again, this all feeds into the argument that Marnie lawyers put forward, that this is all the fault. The fact that there was money lost, that's the fault of the Torrens Assurance Fund, and really the taxpayer should be coughing up to compensate Mr. Kumar. And as I said, that was not accepted. So the purchase price there, number 1, 2, 3. So let's just have a look. And these are some of this is under the heading salient facts. Again, not my facts. These are facts that Justice Dark, the Honourable Justice Dark, found. So we know on the 31st of May, the contract price was 5.5 million. Only 1.5 was put down. But the property was used as a credit card, I suppose, and a mortgage secured the sum of $2.275 million. So 1.5, the fact is the plaintiff received 1.5 million on settlement. And where did the other $750,000 go? Well, the director of Bargo was Craig Adams. So we'd have to ask Craig Adams, but we know that only 1.5 million was ever paid to Mr. Kumar. And that's that. So, and this is the fact. That was the only money that was ever paid out of a $5.5 million sale price. Only ever 1.5 was ever paid. So we know that time was of the essence. There it is. Time was of the essence, and 1.5 was on settlement. There was, after 4 weeks, another $500,000 was required. Time of the essence. 6 months later, another $1 million, and none of this was, this contract wasn't enforced. And not only that, the salient facts that in May 2016, it was hocked to the tune of 2.275, but a further, that's the caveat that I put on. There you go. I put that on. I went into the counter and paid the money, and on or about the 27th of March, and Ralph could sleep at night then. So we know that 6 months later, Mr. Bargo hocked the property again. There was the initial mortgage was to AR Mortgages, and then along came N&M. Now, the very first thing I went and did was wrote to N&M and said, stop lending money, stop lending any more money, and making Mr. Kumar's position any worse. So literally from that day, in March of 2017, they were on notice. And they did not. And I've got copies of the correspondence that went around that night, and before 6 o'clock the next morning in March of 2017, saying, pardon me, I have a habit of dropping the S-bomb sometimes, but number 1, $750,000 went to Craig Adams's pocket or somewhere, and then another 400,000. This is still not going into Mr. Kumar's pocket, despite there being a contract, despite Mr. Kumar having Ralph Palagaru on the ground as his power of attorney. And on top of that, well, there's even more money being borrowed. So another $350,000 was borrowed in August 17, a very interesting date, on the 3rd of, and then even more. So it just goes on and on and on and on and on, more and more hocking of this land. And again, I put N&M on notice of that. Anyway, long story, but there's more and more hocking of this property going on. And in August of 17, even more money was borrowed, and here's a full list. And I mean, I find this extremely interesting. There was 7 caveats. So Craig Adams, obviously, well, there's some very harsh findings here about Craig Adams, but there was Mr. Palagaru deposes. This is his evidence. There were 7 caveats in the end. 7. So 7 lots of hocking of money against Mr. Kumar's interest. And Mr. Palagaru, for whatever reason, he had, from the day I put the caveat on for Mr. Kumar, Mr. Kumar was protected from that point. N&M had notice, do not lend any more money. He's in default to Mr. Kumar. He owes $4 million and he's in default. And another 6, yes, I think that's correct, another 6 caveats on top of the caveat I put on was ripped off, and another 6 were put on. So Craig has just borrowed and borrowed and borrowed and borrowed and borrowed, and in the end, someone said, well, this is the Torrens Assurance Fund's fault. Justice Stark didn't agree with that. So I'm with Justice Stark, by the way. So Ralph further deposes that he was concerned. He was concerned. I was concerned that there was 6 more lots of hocking of money. And in 2017, now this is after Ralph has lifted the caveat that I put on, Mr. Marnie writes to Mr. Adams, oh, we're not very, very happy here, and so you can read this for yourself. But this is something I find very interesting. Paragraph 19. Mr. Marnie writes on the 6th of November 2017, I have now been contacted directly by the representatives in India of Mohan Kumar. I find that very interesting. The representatives in India. So I'm curious whether that's true. That's what it says. That's what the email says. I'm curious if it's true. I don't know. I have no idea. I've never talked to Mr. Kumar ever. But apparently some representatives called. Well, he says, Marnie writes, I have now been contacted. As you're aware, there's vendor finance. As you're aware, you're in default. And, goes on. Now, all along here, no response. There was no response. Craig got the email and just ignored it. Ralph went to Fiji. Some of these things aren't really relevant. But I am dubious about some of this. Not of what... I'm dubious about the evidence that was given. In cross-examination, Mr. Pellegaro agreed that... so, how did Mr. Kumar miss out? Well, a caveat was lifted, and Mr. Pellegaro gave evidence that in November 2017, he gives evidence. Adams, according to this email, Adams knew that the withdrawal form was located in the bottom drawer. So, of the Bargo office. It's a long story, and you'd have to read it, and we'll send you to sleep if we talked about it. But Pellegaro gives evidence that before he departed from Australia, he handed a withdrawal of caveat form in the bottom drawer of the desk I used from time to time. So Ralph and Craig sometimes shared an office. Now, credit to Ralph, Justice Stark actually says he accepts Ralph's version, okay? But still rules against them. He accepts that this actually happens. Justice Stark accepted that he was told orally on or about the 15th of November, you're only to use this in certain circumstances. Craig went ahead and used it anyway. But I'll cut to the end. Before I get there, this is the evidence of Mr. Pellegaro. I'm putting this is what he says. I am putting this, which is the withdrawal of caveat. I'm putting this in this drawer. Do not use it until I have full details of any proposed finance or equity position to be taken by any prospective partner or joint venturer with us. Joint venturer with us. Until I have full details of any proposed finance or equity position to be taken by any proposed joint partner or joint venturer with us. So, with us. So, it's to be, there's an us. These are Ralph's own words. There is an us. And again, somewhere in this lengthy document, it's 27 pages long, somewhere in this lengthy document, Justice Stark ponders why it was that Ralph gave a withdrawal of caveat when, in fact, there wasn't a caveat on the title. At that time. There was in December, and Ralph's evidence is that on the 15th of November, he handed Craig the withdrawal of caveat. But there actually wasn't a caveat on the title on the 15th of November. There was in December. So, and Craig used that to remove the December caveat. But there was no caveat in November. So my handwriting here says dubious. I'm dubious. Here you go. If Mr. Lie, now that really should say question mark. If Mr. Pellegaro's evidence concerning the signing of the withdrawal of caveat is accepted, if it's accepted, The form was signed at a time when the plaintiff had no caveat. Now, Justice Stark found, he accepted Ralph's evidence that it was that on or about that date, he did hand Craig the withdrawal. The plaintiff lodged another one on the 4th of December. So precisely why Ralph gave, this is dubious or curious, or it is very puzzling, but it is very puzzling. But he gave, on or about the 15th of December, the withdrawal of a caveat, for a caveat that hadn't actually been lodged until the 4th of December, 3 weeks later. Very curious. More correspondence. It's Franklin Easy gets a mention. Any refinance is also to result in the discharge of the second mortgage over the Palagaro home in favour of Franklin Easy Holdings. Anything that you do must be referred to us. Ian Jordan comes in, our wonderful friend from Australasian Property Group, who are being sued by the liquidator of Bargo. Now, who appointed the liquidator? That'd be me, the liquidator of Bargo. So when all of this turned to custard, I appointed a liquidator, and I swore that there was a debt of very close to $6 million owed to me. It once upon a time was owed to Mr. Kumar, but courtesy of Ralph Palagaro, on not one but 2 occasions, Ralph assigned that collection to me and the $6 million, and that was in July of 2018, and he went ahead and amended that deed on the 13th of November 2018. So precisely, again, this is why I was absolutely certain that this would fail. This argument that it's the Torrens Assurance Fund's fault that Mr. Kumar lost all this money, it's his fault. It's the Torrens Assurance Fund's fault. Well, no, it was never even remotely possible that it was their fault, because Ralph assigned the collection to me, and he assigned the debt. I went to the Supreme Court of Victoria and said, hey, my company is owed $6 million by Bargo Developments, and they've failed to pay it back in accordance with the terms. Now, we had a look up above. Let's just go up above. It says, Ralph, here's the payment schedule. Well, so time was of the essence. So I gave them 21 days and said, at a certain point, I wrote and said, hey, you owe us $6 million by that point, with, or whatever the figure was. It was over 5. And here's a copy of the... Here's a copy of the demand that was put on Bargo. They never paid, and time was of the essence, and so they were deemed to be insolvent. And so how was it ever possible that Mr. Kumar lost money because of the fault that was caused by the fault of the Torrens Assurance Fund? No. They didn't even have standing to go to court. Mr. Kumar had no standing. His entire loss was given to me and to my company to pursue. And then Mr. Palagaro obviously thought better of it at some point later and decided, oh, well, that doesn't suit me to have Mark Smith collect the money, even though he paid me 9% of the funds, which you can work out 9% of $2 million. It's about $180,000. So it's just very puzzling. So it's a long story. Ian Jordan gets a mention. EBM. Now, these are Craig's accountants. His accounts were a firm called DBW in North Sydney. I've been to their office late one night. The B in DBW was a man called Bardella, and Max Bardella, and Maximilio Bardella, and he loaned money to. He was one of the 6 people that advanced money. His company EBM. As distinct from DBW. DBW helped with all sorts of manner of wonderful documents in support, and all up, look, there's a long list of people that were dotted, but I withdraw that. There's a long list of people that get a mention. So there's, as I said, there were 6 caveats. There's a very huge gap. This I found extremely interesting. Paragraph 37. 3 further caveats were lodged on or about the 29th of January 2018. One of these was lodged on behalf of Reliance Leasing, Mr. Steinberg. So that's a Steinberg there. And on or about the 22nd of February 2018, Marnie appears to have become aware of the refinancing. So again, this is something that I do find very interesting. On or about the 22nd of February. Now this is what was put to Justice Dark. Marnie appears to become aware, and Marnie writes a letter to Craig Adams. Now, I will say, we should go and have a look at paragraph 16. This is really very interesting. Paragraph 16. There is evidence that later in August 2017, Mr. Marnie was acting for the plaintiff, so that's Mr. Kumar, in relation to the proposed development, and was also acting for Craig Adams. So he's acting for multiple parties. And I have, in previous episodes, I said here's Mr. Marnie, how he was able to manage these and juggle these conflicts, or not so much the conflicts, but the conflicting interests. Surely Mr. Kumar has one interest, hey, I want to be paid, and Craig Adams, hey, I like this getting free money stuff, and I can just use this as my credit card. I can keep $750,000, then another 400 for me, and do whatever the hell he likes. So it's a really, really, really stunning thing. So 22nd of February, Marnie writes to Adams, I enclose a copy of a letter to Reliance from the solicitors for the new first mortgagee. The existence is of serious. The existence. So that was Cassinda. The existence of the new first mortgagee is a serious concern to my client. My client's worried sick. He's in jail in India. It doesn't say that, but as my client has a beneficial interest in the whole of the Dural land, $4 million. But you just keep adding. What he's saying, what he's trying to say is, you just keep adding and adding. Currently, there are 9 caveats on the property. Now, this is kind of stunning. On the 9th of March, Cassinda's lawyers, Bransgroves, Kate Cooper, her name is, the senior partner there, one such document was a withdrawal of caveat form that had been signed by Mr. Palagaru. So according to Mr. Palagaru, and the judge believes him, okay? So according to Mr. Palagaru handed Craig Adams, we had a look at a few minutes ago, Mr. Palagaru handed Craig Adams a withdrawal of caveat at a time in the middle of November, at a time when there was no caveat on the land in the name of Kumar. And in paragraph 41 here, it's saying, well, the mid-November 2017 withdrawal of caveat was handed up by Craig Adams on the 25th of January 2018 to your firm, Bransgroves, and that form states, yes, it's the December. This number here is the December caveat. So the withdrawal was signed on the 15th of November for a caveat that hadn't been put on. And Ralph had only gone overseas for 1 week, from about the 17th to the 24th of November. So for whatever reason, Ralph never took that withdrawal of caveat back. And Justice Stark is critical of that later on. And he's also critical and says, well, why didn't you just leave the withdrawal of caveat? You were going to Fiji. Why didn't you just give it to John Marnie? So one must wonder whether John Marnie got the entire story. I'm finding myself going to bat for John Marnie here. I'm just wondering. So, look, it's really quite remarkable. Ian Jordan, Cassinda, on the 9th of March, writes a letter. Cassinda writes a letter to APG, to Ian Jordan, and they say, well, hang on, I don't think you want to be behind Mr. Kumar. So, this is the whole issue about lifting caveats. When a caveat is lifted, we understand from the receiver that Mr. Kumar claims an unpaid vendor's interest in the vicinity of $6 million. No doubt, these are the words of Bransgroves. No doubt your client would prefer not to be behind that claim. For a piece of land that's only worth 5 or 5.5, and there's close to $3 million already hocked, you don't want to be behind someone that's owed 6 because there's no equity. Look, this is a stunning document. Here you go. This is one of the curious findings. I note in passing that Mr. Palagaru gave evidence to the effect that at no time between his leaving the withdrawal in the desk at Bargo's office and March did he receive any communications about any refinancing. He did not receive any communications from Mr. Adams at no time between his leaving the withdrawal of caveat form in the desk in the Bargo office and March 18. Did he receive any communications from Craig Adams about any refinancing of the documents? That's the evidence. Now, I'm going to say Justice Stark is smart enough to be able to read a transcript of the evidence, and that's what he's saying. He's saying, I wasn't there. Okay, I certainly was not there, and I don't know. I didn't listen to the evidence that Mr. Palagaru gave. But Justice Stark, I note in passing that Mr. Palagaru gave evidence to the effect. So he didn't actually give direct evidence that at no time between leaving the withdrawal of caveat and March 18 did he receive any communication. So I'm just going to pause it here, and we're just going to have a look at some things. All right. So at no time between leaving the withdrawal of caveat did he receive any communications from Mr. Adam about the refinancing of the Dural property. At no time, up until March. So I'll just jump down to something else that I've seen offline. Curiously, on the same day, another caveat was lodged by the plaintiff. So what day are we talking about here? This was 3rd of April. Mr. Mahoney sent an email to Mr. Craig Adams. And keep in mind, this is all in the context that Mr. Mahoney is saying, well, it's the Torrens Assurance Fund's fault that Mr. Kumar lost money. It's their fault. 3rd of April. On the 3rd of April, so this refinancing happened on the 25th of January. On the 3rd of April, Justice Dark notes, on the same day, the 3rd of April, another caveat was lodged by Mr. Kumar. So that went on the 3rd of April, and that was recorded. This is all public. Anyone can Google this, look up this, purchase a copy of that. By this caveat, the plaintiff again claimed to be the unpaid vendor under this 2016 May contract. Curiously, the caveat was apparently signed by Mr. Pellegaro as the plaintiff's attorney on the 30th of January. So it's this continual delay from the 30th of January to the 3rd of April. It's months here, months there, inaction, giving Craig all this rope. So I think you can see where this is sort of coming unstuck. But let's just go back to this other. I note in passing that Mr. Pellegaro gave evidence to the effect that at no time. So let's test this. Here's an email. Now, at no time did he receive any communications. Well, that's different to sending it. But did he receive any communications about any refinancing? Well, here's an email, and we'll see who sent me this and how did I get it. 10th of January. Now, that's between December and March. 10th of January, John Mahoney wrote, Craig, Kumar is not happy with the delay in Warriewood settling. Have you issued a notice to complete? Do you need my help if your lawyer can't do it? Oh, I'll just act for you. And I'll keep acting for Mr. Kumar. But I can manage all this. This is what he's saying. This is ridiculous delay that needs to be sorted. Mohan Kumar reserves all rights. But hang on. But if you need a lawyer, Mohan Kumar reserves all rights. But if you need a lawyer, I'm your man. Do you need a lawyer? John, 3:54 a.m. Something's keeping Craig away. John, please come to the city tomorrow and I'll reassign property and loan to you. Please tell me what time you're available and I'll have Adam Tilley meet us and work out guarantees. So all you've got to do is guarantee it and I'll reassign. So the evidence was at no time, Pellegaro gave evidence to the effect at no time between his leaving the withdrawal and March did he receive any communications from Craig about any refinancing. So what's this? Adam Tilley. Who's Adam Tilley? Adam Tilley will meet you to work out financing. Guarantees on financing. Later that day, Craig, it is not my shit, as you put it. Mr. Kumar's rights. And you keep mortgaging his property. 9 caveats later. Before you paid for it, Ralph has signed the transferring shares. So Ralph actually had the right to transfer the shares embargo and transfer the ownership of the company to Mr. Kumar. Therefore, it's in your interest to work to solve the problem. Now, the problem is for you is that not only will you have lost the development value, you're in default of the loans, which are secured. We're giving you until 4 p.m. today, the current payout. Tell us the current payout. If you can't get those figures, Kumar will by next Monday become the owner and serve lapsing notices. So I don't know if this is, 11th. Mate, I tried to call you. This is going to go pear-shaped. So this is from Ralph to Justin Hatfield. Who's Justin Hatfield? Oh, he wouldn't be talking about refinancing because Justice Dark found at no time was there any evidence. Ralph gave evidence to the effect that at no time did he receive any communications from Mr. Adams. Well, I suppose this one to Justin Hatfield is probably not from. But anyway, I'm stuck in the middle. An asset line. Who are they? They're money lenders. Justin Hatfield. As soon as Craig settles Warriewood, has to happen in the next 10 days. One lender, cross-collateralise this and that and whatever, $13.5 million. The current payout figure is $2.7 million to Winchester O'Rourke. That's Adam Tilley. At no time, the evidence was, at no time was there any discussion about refinancing. After Ralph has those figures, Kumar will be in a position to refinance Dural without putting you in default of your loans secured over your property, over 88 Perfection Avenue. Cross-collateralization is in breach of the sales contracts. So a few choice words here. The point is, he was going to refinance with Tilley, Adam Tilley. No news. Warriewood. Who knows? It's almost a Ponzi scheme. And Mr. Hatfield, you have facilitated a lot of it. It's easily resolved once Warriewood settles. What's happening with... At no point was there any discussion about refinancing. Ralph wrote, what's happening with Tilley refinancing? It's fully approved. It's fully approved. So the evidence, did he receive any communications about any refinancing of the Dural property? I'm just not sure whether Justice Stark saw these communications, but they're there. Interesting. Not good enough. John Marnie, still on the 11th. Not good enough. Client has been waiting months for the mythical Warriewood settlement. Time is up. Kumar will now register the share transfer. Well, even in April, still hasn't happened. Also, what is the secret about telling us how much it will take to free Dural of the various blisters? Kumar will not accept any more delays. Well, apparently he will. Justin Hatfield, Lumley Finance and Loans. Now, if this wasn't about refinancing, then, so it goes on and on and on and on. The solicitor is the vendor's worst nightmare. This all comes as Craig not communicating and swearing and So Craig will lose his family. Asset line of ruthless. Mahoney acted against paid on exchange and wants payments. So, but Ralph is organising the logistics of his daughter's engagement. So let's see what else there is. Here's another email. This is to do with, maybe not to do with refinancing, but this is certainly from Craig. We're trying to get, as mentioned, I have Warriewood project settling on the 29th. Yet, so on the 30th, according to Justice Stark, Ralph signs a new caveat, which he doesn't put on until the 3rd of April. And again, all of this is the fault of the Torrens Assurance Fund. Let's have a look at this one. All of these are sent to me by Ralph, by the way. So, from Ralph to Mark. That's me. From Ralph to Mark. From Ralph to Mark. 22nd. Tomorrow. So this property settled on the the use of the caveat occurred on the 25th of January. And look, there was communications between... At no point did he receive any communications from Mr. Adams about any refinancing of the Dural property. Well, I'm going to say I'm sorry that on the 25th of January, there's another communication. But tomorrow. So tomorrow is the 23rd of January. This is before the caveat is used. Gents, Mr. Lalich, this is another one. The evidence was there's no communication about refinancing from Craig. Well, Mr. Lalich is one of Craig's lawyers. So they're meeting up on... Ralph is meeting with Justin Hatfield. And Justin Hatfield, this wouldn't be anything to do with a refinancing, would it? Lumley Finance and Loans, accredited finance broker. I've said I'm dubious about that evidence that Ralph has given, to the effect that there was at no time did he receive any communications. Yet, this is not a communication about refinancing from Justin Hatfield, who's a mortgage broker. Craig Adams, so this is, see you there. So as you can see, there's quite a lot to this particular judgment, and we're only up to page 6 of 27, and it really does go on. But I'm just highlighting a few key bits. I'll just return now to this other thing, and I've said that I am dubious about... I'm not saying that people are outright lying, but I am highly dubious about some of the aspects of what was put in front of Justice Stark. And I'll take you back to this one, paragraph 19. Mr. Marnie, on the 6th of November. Now, this is at a time when there was no caveat on the land. According to Ralph's evidence, on the 15th of November, Ralph then went and handed Craig Adams a withdrawal of the caveat that wasn't on. And then in December, one was put on. So in the evidence, this is Mr. Marnie wrote to Craig Adams on 6th of November when there was no caveat. And he says, and we've talked about this just before, this is what Marnie writes. Now, this is important because he says it's true. And I'll show you something else. So this is on the 6th of November, 2017. Now, I'm going to show you something in 2018 that causes me to be dubious. Mr. Marnie, I have now been in contact directly. I have now been contacted directly by the representatives in India of Mr. Kumar. So someone in India has contacted Mr. Kumar. As you're aware, Kumar is the vendor. There's a vendor finance. You're in default. And in December 17, Marnie is writing, and why are we saying this? Well, Marnie's being paid. He owes a duty of care to Mr. Kumar. And according to his correspondence, he's in contact with them. So he must, if you believe what he's writing, he must accept that he did owe them a duty of care. And so as a matter of urgency, well, there's no caveat. So the caveat doesn't actually go on for another month, and is subsequently withdrawn using a withdrawal of caveat that Ralph did not give to Mr. Marnie. He left it in a drawer, according to Ralph. He left it in a drawer in Bargo's office. As a matter of urgency, as the basis of the encumbrances, a copy of the certificate of title, a copy of the 5 caveats. We have been instructed. So did someone in India? I've been contacted directly by representatives in India. We have been instructed to determine whether all can be removed through lapsing notice or through litigation. So at this point, the first mortgagee is N&M Properties, and they're on notice because of my letter. They're on notice of this interest. So I told them, absolutely do not lend any more money. And subsequent to this, more money was lent. But again, the argument that Marnie Law is using is that this is all the fault of the Torrens Insurance Fund. It's all their fault. All of this, as a matter of urgency, we've been instructed to, start lapsing things. Can we lapse them? Can we have litigation? And there's no response. So there's no response. This is the 6th of November, and a caveat does go on in December and is subsequently withdrawn using a withdrawal of caveat dated the 15th of November or thereabouts. So we asked to find out the current balance on the N&M mortgage. Keep in mind, he says he's been contacted by people in India directly in his email of November 2017. Dear Ralph, please provide me the contact details for the Indians. So he doesn't even know who his client is. He's only dealing with, this is a year later. He's either lost the phone number. Let's be generous and say he's lost the phone number. Please provide me contact details. He doesn't know the name. He doesn't know the phone number. According to this is the way I'd read it. Please provide contact details. No, not just the phone number. Person, phone number, emails, what their relationship. As you are unable to do anything to further this matter, I need to speak with the Indians to have you replaced. Whoa. To have you replaced as their attorney. Why did it take until October 18? The land's been sold by that point. But yet a year before, he's saying in November, the year before, he's saying, as a matter of urgency, we need to find out and start lapsing things. I'm saying, look, let's have a look now. There is I'm just going to throw it up on the screen here. We've got signed by Ralph Pellegaru in July and November 2018, twice. Ralph has assigned a claim that Mr. Kumar would have against Mr. Marnie for professional negligence. Now, I don't know if that claim has legs or not, but Mr. Marnie is being employed and sending out bills for hundreds of thousands of dollars, $90,000 to $100,000 or thereabouts, to Mr. Kumar. So he must have owed. He must feel that he owes a duty of care. It took him until October to 2018, after the property sold, after the property's had 9 caveats go on. It's really interesting. But yet the argument is it's all the fault. Forget all of this stuff. It's all the Torrens Assurance Fund's fault. They're to blame. The state government has to cough up money. I still don't understand why you don't want to save your house, Ralph. I'm still here to help. Well, wow. That's fantastic. Now, let's go back to, this. I have now been contacted directly by representatives in India. Well, I've been in contact with them myself, for several years. Let's have a look at some of the stuff that's being said. Here's what I wrote. I'm not going to give the person's details. Did Mr. Marnie ever speak with any family members of Mr. Kumar in November 2017? Paragraph 19 says he did. Hi, Mark. No. He or Ralph has never spoken to any family member. Only you were the first to approach us. The first! This poor bastard's sitting over in jail in India. Now, this is not Mr. Kumar this is a representative. But this poor bastard's sitting in jail. He's had his $4 million plundered. And I am the first to contact them. First. That's pretty clear. Okay, then I go on. In the court judgment, Marnie gives evidence. He has described he has had discussions with someone in India. In India, not just Ralph, someone in India. The reply, who is that someone? There has to be a name. I believe him. I do believe this man. By just saying someone in court, that does not make any sense. He has to give details. And here's specifically what I did send to the contact. I have now been contacted directly by the representatives in India. In India. No name, paragraph 16. He is just making it up. He's just making it up. Wow. Now, I'm just repeating this. I'm personally speaking for myself. I am dubious. I actually am dubious that this is true. I have now been contacted directly. But this is what a lawyer with 40 years experience is writing in 6th of November. Could he have saved that last 400 grand? Could he have? I don't know. At this point, in November 17, none of this claim has been assigned to me. So he could have saved maybe 400,000 to, he could have saved $2 million, maybe. And he, in his own words, he's saying, well, we have been instructed. Now, if this is correct, if he has been contacted directly, well, he's in the same email, he's saying we've been instructed to determine whether any of the caveats can be removed through lapsing notices. Well, why didn't he do that? He's been instructed. Hang on, you're a lawyer, you're instructed, why don't you do it? So again, we're only up to page 6. It's a staggering document, and full credit to Justice Stark. He does, I think, a very good job with the material he's been presented. Now, he's been presented things saying, well, he's had contacts with people in India. Justice Stark clearly has absolutely no idea and absolutely no criticism. He doesn't know. He makes the observation. We haven't seen Mr. Kumar in court. He didn't come and give evidence. Well, okay, good reason for that. He can't. He's locked up. Apparently. I don't know. So, look, let's skip right to the end now. And I will say this. This is a very long, well, it's not overly long, but it's lengthy and it's well considered. It is well considered. 3rd of April, Marnie sent a letter to Mr. Adams. Mr. Adams. Unfortunately, however, our clients have come to no other conclusion than that you have fraudulently also delivered to the solicitor of Cassinda the withdrawal of caveat. Fraud. It's very big. If you're going to say fraud, the bar is very, very high. In all the circumstances, in April of 2018, in all the circumstances, Marnie's writing, in all the circumstances, we have been instructed, again, he's got an instruction to report your actions to the New South Wales Police for fraud. So, what did he do with that instruction? 3rd of April, he's got the instructions to report you for fraud. And 3rd of April, same day, they relodged the caveat. But he'd been sitting on that caveat since the 30th of January. Now, would it have made any difference? I don't know. I don't know if he'd lodged the caveat on the 30th of January. It may or may not have made any difference. But all I do know is they sat on it. They sat on it. Mr. Marnie or Mr. Palagaro. Where the evidence is, the finding of Justice Stark is that, curiously, the caveat was apparently signed by the power of attorney, Mr. Palagaro, on the 30th of January, when the plaintiff's second caveat remained on the title. So the withdrawal of caveat had been handed over, but it still remained. So Cassinda actually had the withdrawal. At the time, Palagaro signed another one on the 30th. He must have known that the withdrawal of caveat had been used. Yet on the 3rd of April, they're writing letters saying, oh, we've just discovered it. And there was a previous finding on the 22nd. On the 22nd, I talk about this gap. Paragraphs 37, 38. I talk about this gap. 3 further caveats were lodged on the 29th. Now this, and one of these I was involved with in some way, the Reliance leasing one. This was lodged on the 29th of January, and that stopped, putting it on, stopped Cassinda having theirs properly registered, their mortgage properly registered, and the removal of N&M and APGs, and there was obviously this giant clog. Now, Ralph apparently signs the next caveat on the 30th, but at this point, Reliance got theirs on, APG got theirs on, slightly behind the one that I was involved in, Reliance, and then Lumley, that's the finance broker. They got theirs on as well. And then on the 30th, Ralph must have known. So he goes and signs another one, but claims they don't know until the 22nd of February 2018. Mr. Money appears to have become aware of the refinancing transaction. Appears. So that's interesting. Very interesting. And writes, the existence of the new mortgage is of serious concern to my client. Yet Ralph has signed another caveat on the 30th, and it's of such serious concern, he did nothing with it from the 30th of January until the 3rd of April. There are some questions here. So we then move on. The total claim that was made by Kumar against the Torrens Assurance Fund is $1.9 million. Paragraph 59. It is submitted that there are good. Now the Registrar General says that there's good reasons to doubt the evidence of Mr. Palagaru. The Registrar General says that there was good reason to doubt the evidence of Mr. Palagaru. Now we look at the determination. What did the court find? Paragraph 68. I have reservations. So Justice Stark can only deal with the material that's before him. He doesn't, to his absolute credit, I think he's done a brilliant job. Okay, but he may not have had all the material put in front of him, either by Ralph Palagaru or by the Torrens Assurance Fund. They may simply not have known. It's paragraph 68. I have reservations about aspects. He finds some of it implausible. Paragraph 69. Despite my reservations, I've ultimately come to the conclusion Mr. Palagaru's evidence should be accepted. So that's pretty good. But it doesn't change the result. The result is no money. Paragraph 61. I further find Mr. Adams, in making use of the withdrawal of caveat, was acting contrary to the instructions. On the material that was put before Justice Stark, and I don't know if that included those emails. Well, I do know that, I'll put it up again, that Palagaru said that at no time was there correspondence about the refinance. But coming back to paragraph 71, 72, paragraph 71, I accept Mr. Palagaru's evidence to the effect that neither he nor the plaintiff himself had any knowledge of the transaction. That's about the refinancing. Now, again, I do not know whether the emails, the one tomorrow with Lalich and Hatfield, and there's a series of them that I've put up, I do not know whether they've been put up to Justice Stark and considered. But on what was put before him, he says he accepts Mr. Palagaru's evidence. Okay. I'm prepared to conclude that Mr. Adams acted dishonestly in this respect. Paragraph 72. For the above reason, I'm prepared to find that Mr. Adam acted fraudulently in making use of the withdrawal of caveat. But, okay, so that's, to get money out of the Torrens Assurance Fund, there has to be dishonesty or fraud or a mistake by the Torrens Assurance Fund, the Registrar General's Department. And on top of that, you have to prove that it led to loss. Now, that's the whole thing that I've always said, well, hang on, I think you've postponed yourself, Ralph, by handing this over. And look, I'll just show, we'll go through these other pages. There's lots and lots and lots here. Okay, lots of analysis. The plaintiff submitted that the equity, Mr. Kumar could have been $400,000 better off. And now, on top of that, there's interest. Okay, so we're talking still a lot of money here, a lot of money. And there was, as I said, there was a $2 million kitty. APG received out of that fund $725,000. That's $750,000. And Ralph and Ian Jordan, the director of APG, have a company together. I don't know precisely. I was in the mediation in July 2019, but I didn't go and shut the door and chat with Ian Jordan. I didn't. And so APG walk out with a lot of money. Now, the liquidator's now chasing that and saying, well, that was a preference. And we'll see where that all goes. As I said, there's a whole lot of analysis here. And it's going to be impossible to just go through them all. But I'll put this up on our website. Let's have a look at these last two pages. In my opinion, the whole of the loss or damage should be regarded as the consequences of the acts or omissions of the plaintiff. The conduct of Mr. Palagaru as the plaintiff's agent in relation to the withdrawal of the caveat, the very means by which Mr. Adams was able to perpetrate his fraud, that's to blame. So I think, as I said earlier, Justice Stark did find that there was fraudulent conduct, but you've got to say that, okay, that fraud led to the loss. And there's pages and pages of analysis. the bottom line is Justice Stark did not find that it really would have made any difference, whether there was fraud or not. The postponing conduct and the arming and all of that was really... The conduct of Mr. Palagaro was, in my view, plainly negligent. He failed to take reasonable care for the interests of the plaintiff. That is particularly the case in circumstances from November 17. Mr. Palagaro was not only aware of Bargo's breaches, so they'd failed to pay, they had to pay 1.5, which they did on this $5.5 million transaction. Then they had to pay $500,000 within 4 weeks, and another $1.5 million or $2 million or something after that, and then another $2.5 million. So he was aware that they'd missed all of those. There was incredible. I said the 3rd of November 2017. We've got the email from Mr. Marnie, who says he's been contacted directly by representatives in India as a matter of urgency. And yet Justice Stark says, in particular, this is particularly the case in circumstances where from November 2017, Mr. Palagaro was not only aware of the breaches under the contract, but also had concerns about Mr. Adams's dealing, that he's hocking the property, and he knew, he must have known that. He must have known. That's what Justice Stark finds. To make the signed withdrawal of caveat form available to Mr. Adams in those circumstances strikes me as conduct that is very negligent, if not reckless. Mr. Adam utilised the means that were available to him to carry out the fraud. Applying a common sense approach, the conduct of Mr. Palagaro should be regarded as the cause of the claimed loss. $4 million just down the toilet of Mr. Kumar's money. $4 million down the toilet. To my mind, it is a cause of the loss as much as the conduct of Mr. Adams himself. It is a case where there are truly successive causes of the loss. It is thus, it can't be concluded that the loss or damage was as a consequence of the acts or omission of the... Sorry, that it was a consequence of the acts or omissions of the plaintiff, and thus no entitlement. It wasn't the fault of the Torrens Assurance Fund. And just to rub it in just a tiny bit more, paragraph 122, the plaintiff will be dismissed, the statement of claims dismissed. The court will further order that the plaintiff pay the Registrar General's costs. So there you have it. A terrible, terrible tale. We'll come back and wrap up in a minute. Well, how is that for an incredible defeat? Justice Stark has really nailed that, I think, and well, you would think that that's the end of it, but apparently Ralph and John Marnie are off thinking about an appeal. Can you believe it? Thinking about an appeal. On top of that, there is another case which I've just put up the details about. Ralph is also personally suing the Torrens Assurance Fund with his wife Henrietta, and very similar thing around the same time as all of this happened with Mr. Kumar. At a very similar time, Ralph borrowed money at 6% a month, and $540,000 at 6% a month from a company called Franklin Yeasey. And for better or worse, it also for whatever reason, we talked about delays. Incredibly, there was a delay between about August 2017 and December 2017, very similar periods where Ralph failed to put a caveat, or neglected to put a caveat on land at Warriewood, owned by Golden Arrow International, another of Craig's companies, and subsequently he missed out on $540,000 and kept on paying 6% interest a month. And in case you can't work that out, that's like 30-something thousand in the first month, and when you don't pay it, it just balloons and balloons. And like literally, I did some sums at one stage. It was like $54,000 a month interest it was up to. So, but the trouble is, I think I haven't seen the judgment, and if and when I do get a copy of the judgment, or if it's been dismissed or whatever, I'll make sure if I get the documents, we'll post them, and because they're public documents, and very similar facts. I imagine I can't see how he could possibly win where he's going to claim, well, it's the Torrens Assurance Fund's fault that Craig. In this instance, I think they were just slack and didn't put either Marnie or Palagaro was slack. I don't know who, so I'm not apportioning blame there. But what I do know is that there was a period of 4 months and there was no caveat on this Warriewood land. And in the meantime, you saw how many caveats Craig Adams put on Bargo. He put just as many on, maybe just as many. He put enough. There was lots of caveats put on Warriewood as well. And Ralph missed out, and it goes on to pay $30,000 a month interest. And that's clearly not sustainable. So you would think... so where's this all going? Time will tell. Time really will tell. But, to the best of my knowledge, Ralph's insolvent. We've got a we have, I personally have a consent judgment against Ralph, $106,551. We filed a creditor's petition, and Ralph is trying to have it set aside, one that he consented to. So it's going to be very interesting. He's managed to get that adjourned until April. So in the meantime, if there's any if there's anyone out there that also is owed money, a lot of money, you're very welcome to come and join the party. Join the action, join the creditors petition, be a supporting creditor, and it wouldn't surprise me who you are. So again, if you're owed money, come and join the action. If you've got any questions, if you know any facts, if you've got any thoughts, we'd love to hear from you. dcpartners.solutions/podcast, or give us a call 1300 327 123. If you do go to our website, check out the link in the bottom right hand corner. There's instant message chat tool. We'd love to hear from you. And thank you very much. Thanks for tuning in. Bye bye.